the deceased's phone number, Mr. Palmer's phone number, and Mr. Campbell's phone number. So they were the only phone numbers which were the subject of JS2, A, in relation to texts, B, in relation to calls. Now, as far as the texts were concerned, what they consisted of was the following. Text between the deceased and his girlfriend on the 14th and 16th of August 2011. 16th of August 2011, that being the day of the killing, we say. Those texts are summarized in the summing up at E4788 to E4791, and we also summarise them in our case at 6227 paras 40 and 41. But essentially, they're the ones where the deceased is saying, I'm getting more worried. The second set of texts are to and from Palmer between the 8th and the 12th of August 2011. But they appear to be of no importance at all. They don't appear to be referred to in the summing up. They were read out to the jury, but they don't add anything. The third set of texts were those from and to Sean Campbell, which are to an extent incriminating, and they are referred to in the summing up. They suggest that on the day of the killing, but before the killing, Campbell knew that the deceased was going to be executed. He had to die. And they suggest that after the killing, he knew the killing had taken place and they needed to get away. And you can see a summary of those texts at in summing up at 4989 to 4991. That's where they're set out and explained. And importantly, my lords, it is a point you may have wondered, what about the other defendants? Now, it does seem as if texts were collected from the other defendants' phones, but they, after the voir dire, were excluded. And that therefore means there are no texts passing from St. John, passing to and from St. John, or Jones, or Shane Williams. They were originally in the original exhibit before it got to the jury, but by the time it got to the jury, those texts were all gone. As far as the call of telephone logs is concerned, that ran from the 10th to the 17th of August 2021, and what they did was indicate the nearest cell site which picked up the respective calls. And they did show, again, when Palmer was receiving or making a call, likewise Campbell, likewise the deceased, and likewise Chow. I should say, and Chow. There don't appear to have been, as far as I can make out, any texts from Chow. So that's the nature of JS2. But the only really incriminating material in JS2 as such are the text messages passing to and from Campbell shortly before and shortly after the killing. I say incriminating, of course, those between the girlfriend and the deceased are incriminating, but they are not from Campbell, they're from the deceased's phone. I think I've given you the references where you can find it all in the summing up. We don't summarize all of it in the case, but we do summarize quite a bit of it in our case. We have tried to get hold of I think it was Exhibit 10. There are some difficulties getting hold of Exhibit 10, that's all I can say. I have seen what we believe to be Exhibit 10 in relation to the texts. I was handed another exhibit, which plainly was the unedited version in relation to telephone calls. So we haven't put that in. But we can make available what I believe to be the exhibit in relation to text messaging.
And did the judge sum up in relation to the cell site evidence?
No, not really, apart from what you've just shown. I think it's fair to say not much appears to turn on the cell site evidence. I will address you later as to why I say very little turn on it.
Thank you.
Can I say, from the appellant's point of view, one of the reasons for in one sense, perhaps not drilling down into the details of JS2 was for two reasons. Firstly, the clear position of the Crown, as I say, which is to rely on JS2 as being part of the reason why they argue that proviso should be applied in relation to the jury. That, we would submit, is a clear indication of the potential importance of JS2. The other is that, as I've already indicated, the clear indication is that this was a case where, in particular, the only direct witness, Mr. Chow, was someone who appears to have been regarded as unreliable by the jury on the basis of, given the acquittal I've already drawn attention to. And that demonstrates the potential importance of the technological evidence. Can I go back, though, to the point that the reason I was talking about what was being argued below and drawing attention to the fact that there was no debate about the, it's clear, it was accepted that there was an argument that JS2 should be not admitted in light of the Charter, and in particular the breach of the Charter. The reason I draw attention to that is because effectively what the Crown does is argue that what is now being put before this court is a new point. That's a part of the Crown's response. In summary, we don't accept that is right for these reasons. Firstly, as I've already indicated, it is clear that the issue of a breach of the Charter was before the trial judge. That's accepted. Now, the arguments may be different, more nuanced, may rely on authorities that weren't being raised at trial, but that doesn't mean that the issue wasn't before the trial judge. Linked to that, clearly the Court of Appeal's question that relates to this matter is premised on there having been a breach of the Charter. All the way through, and I can give you the references in a moment, all the way through, from trial court up to Court of Appeal, the way in which this matter has been dealt with is on the basis that it appears to be accepted that there is an issue in relation to the Charter, and the question was, what implications should that have? And that's why the Court of Appeal then, we would say properly, referred a question about the approach that should be adopted by trial courts to evidence that's obtained in breach of the Charter. And so we don't accept that this is a case where we're prohibited in some way from arguing what we're arguing. We're arguing the same argument, the same issue that was raised at both courts below, albeit perhaps slightly more nuanced. Now, in terms of the nature of the breach, because our case accepts that there is no automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation, the section 16. Yeah, section 16 of the Interception of Communications Act, which is at 6277, the relevant passage, section 16, the Act, and that is section 16.2, and it is not a complex piece of legislation, which is probably a virtue. It requires a designated person to make a request, and it requires an authorized officer to receive the material. Designated person is defined. Section 16, page 6276, the preceding page. Designated person means someone who's prescribed by the minister. Section 2 defines what is an authorised person, authorised officer, and that's at 6257. It's a number of specified officers within law enforcement. Two other features of this legislation that are worth noting. Firstly, if you go to 6279, section 17 links compliance with section 16 to admissibility of evidence. And section 4 demonstrates in one sense that what this act is about, consistent with the terms that of the legislation that I've taken you to already, because section 4 is concerned with warrants essentially for interceptions, and what that demonstrates in my submission is what this act is about prescribing safeguards in circumstances where what the Jamaican state is and what Jamaican law enforcement in particular is seeking to do is interfere significantly with the rights of individuals to privacy. So it is a piece of legislation that's intended to put safeguards in place and clearly requiring officers of sufficient seniority essentially to authorise gathering of data. It is an important part of seeking protection, of protecting the rights of privacy. Now, in this case, Corporal Brown was the officer who made the request, as I'm sure you've picked up. He said expressly that he was at page 1631 of the bundle, line 19. He said expressly that he was familiar with the Act, and that was hardly surprising because his whole role, as he gave, which he, according to him, when he gave evidence, was essentially to make requests under this Act, and you'd see that at 1574. Line 5, on line 5 to 13. Now, there's been an issue about what he was cross-examined about, and that's raised by the Crown in their case. He was cross-examined about his knowledge and a compliance with section 16. If you go to 1632 in the bundle, he expressly said that from line 24 on until line 4, the following page, that he knew that there needed to be compliance with section 16, and he believed that the notice that had been sent to Digicel complied with that. Now, that is in one sense a slightly surprising answer, given what he says almost immediately afterwards, because he was then cross-examined about the need for a designate.
I know how this looks, but this taco night, it's going to be great. With McCormick by your side for over 130 years, it's going to be great.
Recognises that he wasn't designated. Says that twice, in fact. I'll just give you the reference. He also says it at page 1641. And so on the face of it...
He's not designated, but he is authorised to receive.
He claims he's authorised to receive. I think it's the Court of Appeal found he wasn't authorised to receive, but he.
The judge accepted he was in the voir dire.
Well, I'm not sure the judge actually expressly ruled on that, but certainly the Court of Appeal was of the opinion by the time that they've got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem is, and if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear. So, Melanie, that's why I assume the Court of Appeal said what it said, because on the face of it, it's difficult. Although that was his answer, he clearly doesn't come within the definition, and there's no evidence to explain how authority was in fact given. So that's why I think the Court of Appeal, I don't know, slightly speculating there, but that would be a good reason for the Court of Appeal to say what it said. But it may not matter, because in one sense, there was non-compliance. There clearly was nobody disputes there was non-compliance, and that may matter to some. I suppose the way which it may matter is it may go to how serious the breach was. But I mean the clear problem here in our submission is Corporal Brown is saying, and I'll give what I understand may be his answer to this in a moment, just take you to it. Corporal Brown is saying, I know about Section 16. I know you need a designated officer. I know I'm not a designated officer, effectively. So on the face of it, that's a problem. Now, what he does suggest is if you go to 16.4.3, and this is all just to make clear in the course of cross-examination, which is clearly intended, we would submit, to determine why this breach occurs, and 1643 2022, line 22, not 2022, Corporal Brown indicates that there may have been, that others may have been designated.
He names it.
He names them, yes.
922.
Yes. He names two officers, ASP Pascoe and Inspector Williams, as potentially others who may have been designated. But he accepted, if you go on to 1646, that he did not know whether or not they'd had the benefit of an affirmative resolution. And you will remember that the terms of the legislation are clear, that you need an affirmative resolution. And he accepted that he, in one sense, he needed to rely on them having that authority, because he accepts at 1652 that he knew the request was not from a minister. And so you have on the face of it, Corporal Brown saying, I know what the legal obligations were, but essentially I've assumed compliance with them. And you see that reference to assumption, that's his language, not mine, essentially, at 1653, lines 13 and 14. And that, in our submission, suggests that this isn't, that there is at least a degree of negligence, essentially, here, in the sense that this is someone who understands it's his job. He understands that he is subject to legal obligations. He doesn't check effectively compliance with those legal obligations.
Doesn't he at some point say that advice had been taken?
That's, I think, if I remember rightly, there is a reference to that. I think that may be the Digicel witness from memory. I'd have to double check that. But I think it was there was reference to advice, but I think that was the Digicel witness.
Perhaps we can come back to that.
Yes, but my learned junior has confirmed my memory.
Grateful. Thank you very much.
I'm always just a little cautious about saying things on my feet, but I think that's right. Yeah. it was the digital witness. And of course, the other factor here, which is something the Court of Appeal highlights, is that the Court of Appeal had already, by this stage, by the stage of the investigation, not the stage of the trial, but by the stage of the investigation, made clear that there was that what the terms of the ICA were, the legislation were, in a judgment called Phipps. And the Court of Appeal point this out at 137. So it wasn't as though, I mean, the problem with taking advice was that that might have explained an initial failure to comply. But if you look at 137, which is 5828, they highlight the fact that Phipps demonstrated a flawed approach similar to that adopted by Corporal Brown. And that raises the question of, in one sense, even if Corporal Brown is effectively the relatively low-ranking officer who perhaps hasn't picked up the latest Court of Appeal judgment, why action wasn't taken by those in command of him? And that's one of the things that the Irish Supreme Court have emphasised when looking at responsibility for compliance with constitutional rights. It's not simply the person who's on the ground that you need to worry about. It's what happens higher up the chain and why the system essentially was operating the way it was. I mean, this was a situation where the Jamaican police had been told in Phipps, your process is wrong. And yet there was no evidence essentially explaining how you then had Corporal Brown making the same mistake or a very similar mistake. Now, the Crown argue that it wasn't put effectively that the police or indeed Digicel acted negligently. A few things about that. Firstly, it was the Court of Appeal themselves who essentially pointed out the non-compliance with Phipps and the issues that arose in relation to that. Secondly, but perhaps more importantly, the word negligent wasn't used in cross-examination. I accept that. I can't find any reference to that. But the questioning clearly focused on the actions, whether effectively the actions of the police demonstrated that they were disregarding their legal obligations. What the questioning was focused on was how Corporal Brown had been in this position when the provisions were clear. Thirdly, in any event, I'm going to come on to make the point, based on case law, particularly Mohammed, that the burden was essentially on the prosecution to show to explain essentially why there'd been non-compliance with the law. And it should be noted, just one reference in relation to that is of some significance. If you, at 1966,
there's no reason to think, had Corporal Brown been designated and authorised, there's no reason to think that this material would not have been provided. There was no substantive reason why that material wouldn't be provided, is there? I'm just asking.
Well, the way in my submission to approach that, and can I, in one sense, take issue with the way the question's phrased, rather than, and I will answer it directly if I can as well in a moment, but I'd take issue with the question. In our submission, if the Crown is going to say it doesn't make a difference, it has to adduce evidence of that. Now, in a case like this, the role of the minister and anyone who's been designated by the minister is important, because it is essentially intended to act as a check. It's intended to ensure that the police can justify a substantial interference with privacy rights. Now, the way in which you it would have been potentially open to the Crown to call, for example, the minister or someone they designated and say, who could have said, I'm the designated person, I've looked at this, there was a good reason for making that material wasn't produced. So one simply doesn't know that. So
the investigation of a very serious criminal offence targeted at people alleged to have been involved in that very serious criminal offence would have justified disclosure of this material?
Well, you need a sufficient. I mean, you can't because of the privacy material.
Okay.
You can't.
You don't
just,
accept.
I can't. I don't accept as a matter of principle
Okay.
that you need enough. You need a good basis for believing that evidence may be relevant. Of course. I mean, the whole point of the legislation, it seems, we would submit, is to strike a balance. So it's to recognise that there may be circumstances in which the evidence will be of value and to enable a route by which it can be obtained, but restrict those circumstances by putting checks in place. So that's why we would submit that on the material available, one simply doesn't know whether a designated person would have. And
whether a designated person would have made the application.
Sorry, whether the designated person would have authorised it, yes.
Well, the designated person doesn't authorise the notice to.
Yes, because that's in one sense, the author. My lady was asking me the point about designated officer and authorised officer. And in one sense, the designated officer, in a very real sense, the designated officer is the more important safeguard because he or she is the person who gives authority,
Yeah.
and they're the one who needs to ensure that there's a sufficient justification. I assume the reason why an authorised officer is need to receive the material is to make sure its privacy is subsequently protected.
Yes.
But the authority is given by the designated officer, and they're the person, in one sense, who is perhaps the more important safeguard.
How do you square that with your submission about the importance of the material?
Well, when we look at the material now, we know that the material found was important. But that doesn't mean at the time the application was made, there was justification, because obviously when making the application, you don't know what, as far as I'm aware, there was no reason to believe that there was knowledge essentially of what that material would show. That doesn't mean it wasn't justified making the application. It may be that the officer had sufficient information to demonstrate that there was reason to believe there were telephone communications. But we now know the relevance of that material. The question that we don't know in my submission is whether a designated officer, knowing what was known at the time the request was made, would have been satisfied that the justification outweighed the interference with privacy. And that's an important safeguard. That's clearly why the requirement for a designated officer exists. It's to stop fishing expeditions. It's to ensure that there is a proper basis for making the application. So can I just draw attention to one other reference in the material about this, which is going back to the point I made about the need to, in one sense, have material about the system and how Corporal Brown wasn't effectively given clear directions as to what he needed to do with. If you go to 1966 of the authority, not of the authorities, of the electronic bundle, line 10, there is a submission there made by the Crown, albeit one that's made apparently without an evidential basis expressly for it, because no evidence was called from a commanding officer, as far as I can see. But in support of the submission that Corporal Brown was acting in good faith, the reference was essentially that this procedure had been dictated to him. Now, that raises a question. That's why, in one sense, we submit, it's striking that there was no evidence about the command structure, how this system had been allowed to remain in place, despite the clear terms of Section 16, and despite the clear terms of Section 16, and despite the judgment of the Court of Appeal. And the Crown makes the point, or argues, essentially, that the defence didn't argue that Corporal Brown's acts were, they didn't challenge the submission that Corporal Brown's actions were in good faith. Firstly, we would submit that making whether or not the actions were in good faith sets up a false dichotomy. Essentially, there isn't in our submission a simple distinction between actions that are in bad faith and all other actions. The reality is that breaches of constitutional rights, such as those in this case, fall on a spectrum. For example, somebody can act in good faith but still be negligent by simply not paying sufficient attention to their legal obligations. They can act in good faith, but there can be a failure by those in command of them. Secondly, the submission that is highlighted by the Crown about good faith was essentially an argument that good faith was irrelevant to the breach of the legislation. It wasn't essentially a submission about how the court should approach the consequences of the breach. In terms of the consequences of the breach, the submissions, as I say, were pretty clear that there was an argument, essentially, that there'd been a breach of the Charter and that should lead to the exclusion of the evidence. And the trial judge recognised the significance of arguments about the breach of the Charter. The trial judge, if you go to 2237, bottom of the page, lines 23, the trial judge indicated he recognised the force of the arguments that there'd been a breach of the Charter, apparently accepting that there'd been a breach of the Charter. But at 2240, at lines 13 to 20, essentially, he cited Khan, and in particular, 2240, he cited Phipps, which is the Jamaican Court of Appeal Authority, which indicates that...
I think he cites Khan on 2240.
224, well, right at the bottom he cites Khan. He cites Phipps before Khan. Sorry, I was misreading my own notes. I'd gone to 2241, and that's what was slightly confusing.
Yes, I see. 2239.
Yeah, he cites Phipps. He then cites Khan, and what he does at line 20, rather, at 2241, is he indicates that essentially that the breach of the convention does not mean the trial is unfair. And applying Phipps, if you then go over to 2242, line 17 onwards, he indicates that the issue is relevance and not how the material was obtained. So on the face of it, particularly at 2242, what he's doing, applying Phipps, which itself goes back to Khan, which we submit is the wrong approach, he directs himself that the only issue really is the relevance of the material. It doesn't matter that it was obtained in breach of the Charter. And that's, we would submit, the approach that was adopted by the Court of Appeal as well. If you go to 5833,
Sorry, page?
Page 5833. 147, you see the application of King and Phipps, and then if you go on to 5836, top of the page, which is the end of paragraph 150, the judge adopted essentially the correct approach. The indication is that the judge adopted the correct approach applying King, and that led to the rejection of the arguments about the Constitution. And so the Court of Appeal proceeded on the basis that there was a constitutional issue raised, a charter issue raised, but rejected it given the application of King and given the application of Phipps. And we submit that is a misdirection, and that had this been approached properly, given the evidence I've taken you to, and in particular the absence of evidence to explain essentially how it was that Corporal Brown, despite apparently being aware of his legal obligations, didn't ensure that there'd been compliance with those legal obligations, we submit that in those circumstances that the evidence would have been excluded. Now, the reason we submit it should have been excluded is this. Firstly, it's important to start with the Constitution and the Charter. And the Charter in our submission, the reason for that is that we submit, obviously, that it's important to look at what the Charter itself says to see what approach essentially should be adopted to breaches of it. And the Charter is electronic bundle 6248.
6248. Thank you.
Just before you move on to this, are you submitting that the approach in Phipps and King is that one is not concerned at all with how the evidence is obtained, that there's no discretion?
I'm submitting this, that King and Phipps, certainly the way the judge understood this, and I wouldn't disagree with this, is concerned ultimately with the impact on the fairness of the proceedings, not how the material was obtained. Now, there are circumstances possibly where how the material was obtained may have an impact on fairness. I mean, if you torture someone, that would probably have an impact on fairness. But the critical difference between that and Muhammad, which is what the approach of this court to written constitutions, is that what Muhammad does in our submission is recognize that there is a significance in a state incorporating rights within a written constitution, effectively elevating those rights as being ones that have to be given particular weight, and that even in circumstances where perhaps there isn't
It's taken my family generations to perfect the perfect curry. Patax makes perfect.
the interests of the state in admitting the material. And so the fact of a breach has to be given weight. And Muhammad recognizes that that is a different approach to King. He expressly says that.
So do you not take into account the fairness, the impact on fairness as part of that balancing exercise at all? You just weigh breach as against interests of the state in disclosing.
Well, you can't, obviously, because you have a constitutional right. Now, I'm not arguing you can have an unfair trial, but the nature of what you can have in my submission, that I'm not saying you wouldn't take account of that. What you can have is a situation where the nature of the breach is sufficient on its own to justify exclusion, because the nature of the breach...
Yes, no, I understand that, but I thought in answer to my Lord's question, you were saying you don't any longer, as a result of the Charter, have regard to the impact on the fairness of the trial?
Well, can I just slightly modify my answer? I was referring to Mohammed, and we obviously go one step further, arguably, by referring to the Irish case law. So we would potentially go a little further, and I'll come on to the Irish case law in a moment. But before I do, what I was trying to do, just to be completely clear, is draw a distinction between the King and Phipps approach, which is simply focused on the fairness of the trial and doesn't necessarily give any weight to the significance of the breach, and the Mohammed case, which does give weight, and very real weight, to the significance of a breach because of the importance of a written constitution. If I suggested that fairness wasn't a factor, then that was lazy language on my part.
So you accept it is a factor?
Yes. It has to, yes, I would accept under Mohammed it has to be a factor. Yes. Yes, but as yes, just to re-emphasise though, the critical point about the Mohammed case law is it gives weight to the inherent significance of a breach of the Constitution, and so it can lead to exclusion simply on the basis that there is a need to protect and vindicate constitutional rights, and that's the distinction we would draw. Going to the Charter, that's, as I think I indicated, 6248. I should say we've used this unofficial version. I've had this issue before. That there is, as far as we've ever been able to discover, there is no official version of the Charter, of the amended Constitution, including the Charter. So you can find the legislation that includes the amendments to add the Charter. You can get a version of the Constitution that doesn't include the Charter. This is the only version that we've ever been able to discover of the fully amended Constitution, and that's why we refer to it. But it is formally from an unofficial source. There doesn't appear to be an official source which is for the Constitution fully updated. The key provisions, firstly, to draw attention to, can I draw attention to section 13(1)(a) and C first? They are, well, the whole of section 13(1), really. The first point I wish to make is that section 13(1)(a) imposes a positive duty on the state to promote observance of human rights. Now, that is, in our submission, a demanding standard, and it's not, it goes beyond a mere obligation to comply with the human rights standards contained in the Charter. And it's part of the context in which admissibility questions should be viewed. Obviously, a key way of promoting observance with human rights is to ensure that non-compliance with the Charter has consequences. 13(1)(c) I draw attention to because it demonstrates, and there are other features of the Charter that reflect this, the fact that Jamaica's approach to human rights goes beyond, in one sense, a European approach, because it applies to all persons. The obligations under the Charter apply to all people. And that was, looking at the debates, a positive decision. And it demonstrates a key feature, and I'll take you to some material that makes good this submission, of the Charter, which is a desire, essentially, to enhance rights, reflecting the fact of Jamaica's independence. Section 13(2) then indicates that effectively the rights that follow in section 13 have to be complied with, save as may be demonstrably justified in a free and democratic society. Subsection B makes it clear that no organ of the state shall take action which abrogates, abridges, or infringes those rights. That's important for a couple of reasons, we would submit. Firstly, it makes it clear that there is an obligation on the courts, because as an organ of the state, essentially, to ensure that those rights, the rights that are incorporated within the Charter, are not abridged. Secondly, when read then with subsection 3J Roman 3, which is about the privacy of communications, it explains why in our submission it is clear that a failure to comply with the relevant legislation, the Interception of Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided, effectively, the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reed made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why in our submission it is right to it's right that the courts below proceeded on the basis that there was an interference with the right to privacy. Now, one thing I should just touch upon is that the prosecution say, well, it's absurd, I think is their language, to argue that the constitutional rights of Mr. Chow, or the deceased, or his girlfriend were interfered with. In our submission, firstly, the approach to waiver will become clear when I come to jury rights, and in our submission there's no suggestion of waiver. But in any event, it misses the point. The whole point about the Interception of Communications Act is that in a modern society, clearly there is a huge amount of data held by held on all of us by people like communications companies. So there is a need for safeguards, because there's no reason to believe that the material obtained was necessarily restricted to the deceased, his girlfriend, or Mr. Chow. All the indications are sort of indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we've made this clear in our written statement of case, there are issues that potentially arise if the state breaches constitutional rights. There are fair trial issues, not least because, in one sense, the state then has an inequality of arms. It has used the powers it has in an unlawful way. The other provision we draw attention to, because it was touched upon by the trial judge sort of indirectly, is if you go to section 19.4, section 19 is essentially concerned with redress. And in particular, section 19.4 recognises that although the Supreme Court may, has jurisdiction generally to deal with breaches of the Charter, appoint the judge made, there is a need, because redress has to be effective, for other courts potentially to exercise their jurisdiction. That links, we would submit, to the Brandt case, which we've referred to in our statement of case, which indicates it could be an abuse of process, essentially, to go to a court like the Supreme Court in the course of criminal proceedings. And we would say that the more fundamental point is that we can make about section 19.4 is it demonstrates the importance of redress being effective. And that, in our submission, is part of the reason why it's important that in appropriate cases, evidence obtained in breach of the Charter is excluded. The Charter itself is, just to be clear, an unusual provision within the Caribbean, in the sense that, and this is recorded in a book that we've included in the authorities, page 8334, the Oxford Handbook of Caribbean Constitutions, is that Jamaica is one of only 3 countries that has made significant changes to its independence constitution. In Trinidad, they are described as being cosmetic. In Guyana, they were concerned with the presidency being introduced. But in Jamaica, obviously, they were focused on human rights, and that's important. Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in 2 ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions. And that's partly why we submit we're entitled, for example, to refer to the Irish Constitution, because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted when the legislation passed through the Jamaican Parliament, it is set out at 8211, and that is that there should be a limited preamble reflecting the historic background, essentially, to the legislation, but most importantly, making it clear that what the legislation, the Charter, was intended to do was produce, and I use these words because they're found in the preamble, was produce more comprehensive and effective protection of fundamental rights. So the clear intention of the Jamaican legislature when adopting the Charter was to enhance human rights. And that's reflected, I think, given time, I'm not going to take you to it, but we would refer you to the judgment of the Chief Justice of Jamaica in the Robinson case, first instance, but it is a judgment of the Chief Justice reviewing the significance of the adoption of the Charter, and that's particularly paragraph 203.
Page.
Sorry, it's page, yes, sorry, I should have given you the page. It's 6472, particularly, in fact, paragraph 6475N. And so there has been reference, it's not my term that I came up with, as to how the Charter is a Jamaicanized version of human rights, or it's a Jamaicanized approach to human rights. That's the context in which one should look at Muhammad. And Muhammad is in one sense, perhaps the least we ask for, or the least we argue for. In our submission, it reflects the current approach of this court to written constitutions. Now, Muhammad starts at 6301, and it was concerned with a breach. You see it at para 11. It was concerned with a breach of constitutional rights resulting from the admission of a statement. Now, my learned friend says, essentially, just to address one point, that there is a difference, because what happened was in Muhammad was a breach of an express provision in the Constitution. He suggests there's a distinction here, but in our submission, nothing in this judgment indicates that there are different types of rights protected by written constitutions. The fact of the matter is, either there was a breach of the Constitution here or there wasn't. And as the issue is identified at paragraph 11, the issue in Muhammad was the consequences. And the approach of the Court of Appeal, having rejected an argument based on US case law, essentially that there was an absolute exclusion, the approach of the Privy Council, essentially having reviewed a number of other judgments of a number of other courts considering written constitutions, is at 28 and 29 of the judgment, which is 6308. Couple of points just to highlight a few things. Firstly, and it's important given the facts of this case not to lose sight of this, at the top half of paragraph 28, the court makes it clear that if there's a dispute about facts, the burden is on the prosecution, essentially. And that it was said to expressly include, for example, whether there was deliberate infringement of the rights. And that's important in our submission. Firstly, it clearly reflects the criminal standard of proof, but it does in our submission demonstrate in a case like this that if the Crown is going to say, for example, we could have obtained this material in any event, it needs to demonstrate that by evidence, essentially, as to from the relevant designated people. It also needs to explain what happened in relation to leadership in this case. Now, in terms of the test to be applied, the court notes, and I accept it expressly says this is in the context of Trinidad and Tobago, and that's important in one sense because obviously each constitution will have its own features, and as I've already indicated, Jamaica has this unusual feature of having adopted a deliberate, rather having rejected or amended the independent constitution and replaced that with a constitution which was intended to reflect a lengthy debate that had taken place within Jamaica. But it said in the context of Trinidad and Tobago, the approach is neither prima facie exclusionary nor prima facie inclusionary, but there is a need to weigh the interests of the community against the interest of the individual who's been exposed to an illegal invasion of their rights. Now, that is the context of then what follows in paragraph 29. And paragraph 29 is quite clearly a rejection of the King approach on the basis that there was a distinction to be drawn between constitutional rights and common law rights. And the reason it does that is because it indicates that it's of fundamental importance that a right is important enough to be contained within the Constitution, and constitutionality has to be given meaning. It shouldn't be meaningless. But it recognises that it's also necessary to consider the nature of the guarantee and the nature of the breach. The ultimate conclusion quite clearly is towards the bottom of the page, where the court talks about breach of a constitutional right being a cogent factor militating in favour of the exclusion of the confession. And that's the critical point in one sense, going back to the question I think my Lady Simler asked me. The difference between the approach adopted in Phipps, the difference between the approach adopted in this case and Mohammed in our submission is quite clearly the fact that there is a need to consider the circumstances of the breach, and that breach itself per se is an important factor that potentially results in exclusion. And that is simply not the approach that was adopted by the Jamaican courts. Now, what we've sought to do, though, one of the issues that potentially arises from Mohammed, and it's one of the reasons why we've gone further in one sense and looked at JC, the Irish authority, is this. One of the difficulties in practical terms we would submit for a trial judge faced with a Mohammed argument is that, as with any balancing exercise, it can be very difficult to work out what weight should be attached to a breach of the Constitution, what factors are particularly important. And that's important because the temptation will always be to admit something because it seems of importance. There's an understandable reluctance to exclude evidence that potentially is important evidence of guilt. But the risk of that in the long
Use Kayak to find the hotel you want at the price you want. Download the Kayak app now.
Breaches should have consequences. If they don't have consequences, then the Constitution is undermined. And JC in our submission, one of the reasons why JC is important is because JC is based on similar idea. It's based on the idea that there needs to be a balance, but it's an attempt to give, in one sense, greater clarity. And the Irish Supreme Court expressly recognised the importance of clarity, because clarity means that the consequences of breaches are foreseeable. It means that the incentive essentially to breach is less. And that incentive, I mean, minimizing that incentive is important. And it links in one sense, thinking about it, to a point, again, that my Lady Simler made to me a moment ago, which is, wouldn't this material in any event, paraphrasing, wouldn't this material in any event have been admitted? If it would have been admitted in any event, the question immediately becomes potentially, why was the shortcut taken? The police knew about Phipps. Why were they taking the shortcut if they could have obtained this material in any event? And that's one of the reasons why it's important to have clear guidance, because police officers in those situations need to understand what the consequences of their actions are. JC is in the authorities bundle it's in the bundle at 6641. And we submit it is of significance for a number of reasons. Firstly, the Irish Constitution, obviously, like the Jamaican Constitution, represents decisions by a relatively newly independent state as to what rights should be given particular protection. Secondly, And if you need a reference to this, it's in the judgment of Mr. Justice O'Donnell at para 97, page 6670.
Sorry, paragraph?
97.
Thank you.
Like the Jamaican Constitution, there is no express rule dealing with the exclusion of evidence. So what the court was trying to look at was what should be the implied rule, effectively. Now, what there is within the Irish Constitution, if you go to paragraph 4.18 of the judgment of Mr. Justice Clark, which is essentially the lead judgment on the approach to be adopted at 6686, there is an express obligation on the state to vindicate the rights of the citizen as far as possible. So there is a positive duty on the state, essentially, to protect rights, a factor that was relied upon. Here, we've already made the point about the language, particularly of section 13.1 of the Charter, which in our submission does impose, perhaps unusually in a human rights context, positive obligations on the Jamaican state to promote rights. Not only that, the Constitution includes a right to adequate redress. I took you to the provision, I think it's section 19. And it makes, sorry?
Redress for what?
For a breach of the Constitution.
Of whose? I might have imagined the redress might be for the breach of the constitutional rights of the person who was seeking redress.
Well, yes. I mean, obviously that's an important...
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need...
That's what you're seeking to do in these proceedings.
Sorry?
And that's what you're seeking to do in these proceedings.
Well, that's what... Yes, because yes, because that... Well, it goes back to the Muhammad...
It's not your constitutional rights that were breached on any view. It's not the rights of Mr. Jones and Mr. St. John.
That's... Well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them.
That's Mr. Campbell.
Yes, Mr. Campbell. But the more important point in any event is that what this case law, what Muhammad it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
But Muhammad was dealing with a breach of the defendant's constitutional rights in relation to the obtaining of a confession.
It was dealing with a breach of his rights, but it was referring to but it was referencing the importance of breaches of constitutional rights generally. It was referencing the need to uphold the standards of the Constitution, and it goes back, if you consider the Jamaican provision, and it's why I started with it in one sense. Article 13.1 makes it clear that it's a positive obligation on all parts of the state, essentially, to promote human rights, to not another way of phrasing that would be to not turn a blind eye to a breach of human rights. And that's, in our submission, what Muhammad is concerned with. I mean, if you think about the facts of this case, you had, on the evidence that you've got, the police were aware of their obligations following Phipps. You had individual officers who clearly were aware of their need to comply with Section 16. On the face of it, at the very least, they didn't investigate whether they were complying with Section 16. That, on the face of it, is a breach of the Constitution, and yet, on the approach of the Court of Appeal and the trial judge, that has no consequences. What's in one sense to stop police continuing to adopt a procedure which is clearly in breach of the Constitution. And that's why in my submission, the point that that's made by the Irish Supreme Court about there needs to be a sort of clear rules to ensure compliance with constitutional rights is important in my submission. Lord, given time, I'm going to try and speed up a little bit, but just to be clear, the approach of the Irish court is based on the features I've drawn attention to, and based on also the need for consistency in approach, which you see at 4.16 of the judgment. It's to set out essentially a clear set of rules that you see at paragraph 5.1 onwards of the judgment. They are said to represent, see paragraph 4.22, the need to balance the encouragement of enforcement agencies. It's at the bottom half of paragraph 4.22. The need to balance compliance with the value of the evidence, essentially. And that compliance is important in my submission because, as I say, if there's no weight given to that factor, there is nothing to stop the police continuing to effectively ignore the Phipps ruling, ignore their obligations under the legislation, and simply and breach privacy rights. Now, what the Irish court does, and I'm just going to go through it very quickly, is it sets out a clear set of tests that focus essentially on the degree of culpability. And that's, we would submit, consistent in one sense with Mohammed, because Mohammed recognises that the nature of the breach is important. What it does, though, is give greater clarity to the nature of the relevance of the nature of the breach by focusing on whether it was a deliberate breach, considering the role of senior officers at paragraph 5.9, and then also considering the potential significance of negligence or recklessness. Given time, I'm going to, because I want to spend plenty of time on the jury point, I'm not going to go into JC in any greater detail, but clearly, had the JC approach applied in this case, and we make further submissions in our written case as to why JC should be followed. In our submission, if the JC approach had been followed, the prosecution simply couldn't establish why there hadn't been leadership, essentially, that ensured systems were in place to avoid this. And that, at the very least, we would say is gross negligence.
If it had been followed, the prosecution could not have established what?
JC had been followed. The prosecution couldn't establish why there were systems in place, what legitimate reason there were for not having systems in place that ensured compliance with the Act, in circumstances where they'd already known that there was an issue following Phipps. And that, at the very least, we would submit is gross negligence. On the face of it, nothing appears to have been done following Phipps.
And you say that would outweigh the balance on the other side?
Yes, because otherwise this is a case.
No, I
where-
understand. I just wanted to be
Absolutely, yes,
clear.
absolutely.
Outweighed the public interest in.
Absolutely.
Yeah.
That having been said, can I just add one qualification to that, which is that, I mean, in one sense, that the way in which that would potentially come into to play would be if the court is considering applying the proviso, and there would be, in our submission, a potential, if the court was effectively thinking of rejecting on that basis, there would potentially be a value in having a retrial on that issue because of the value of, in one sense, the correct approach, the weight to be given to the constitutional breach might be an issue for the Jamaican courts. I'm not inviting I mean, ultimately, we submit the appeal should be allowed, but I'm just looking at, in one sense, a hypothetical example where, or a potential outcome, which is the court coming to the conclusion that the test was wrong, but the correct test would have made no difference. And I just would add a note of caution about this court. If it's a balancing exercise which has to give weight to non-compliance, question mark really whether this court's in the best position to assess that, given the importance of, in one sense, local assessment of the importance of the Charter. Can I then turn to the jury issues? Couple of preliminary points about the jury issues. Firstly, that it is in our submission important to consider the jury issues together. In part, although we would say that any of the individual jury issues are sufficient for us to succeed, in part because if we're right that ultimately the question that this court has to ask itself is whether the fair-minded bystander would conclude there's a lack of independence and impartiality, everything to some extent comes together because it's ultimately the final position that was reached. Was that verdict reached by a body but which, by the stage it was reaching its verdict, was independent and impartial? And that's a reason potentially for considering everything together. And they do link in one sense, because obviously one of the concern, you'll be aware that we make submissions about what's described at times as the second incident, which in one sense for our purposes is actually the first incident, which is the juror who was discharged. But of course the juror who was released from the jury, one of the reasons that is of potential relevance is that seems to put pressure on the trial judge because he can't release any more jurors. And that's where he gets into this difficult situation where he knows that there is a juror who is attempting to bribe members of the jury, but they are allowed to continue to serve. Had they not been allowed to continue to serve, then the jury would have had to be discharged because of what had happened the second time.
So there were three incidents. I don't think you're making any submissions in relation to the first.
No, exactly. That's why I was saying.
So we refer to incidents 2 and 3.
2 and 3. I was going to use that language, but I was in one sense, in terms of what we're arguing, 2 is 1, but that's where the slight complication came from. But yes,
we better stick with 2 and 3. I think.
I wanted to make clear. I wanted to make sure everyone was using the same language in that way. Yes, absolutely. The second thing is that, in particular, in relation to and it's important not to lose sight of this when one gets into the detail, in relation to, in one sense, that the third incident in particular, the Crown puts very heavy weight on the directions given by the judge. Now, I'll make some submissions about those directions, but there is a fundamental problem in our submission by the time of the third incident. By the time of the third incident, the judge is proceeding on the basis that one of the jurors has attempted to bribe the other members of the jury. He's committed, potentially, a very serious criminal offence, and we in fact know he was convicted of that serious offence, and indeed he was arrested immediately after the verdict. While it may be right to assume for many jurors that they will comply with directions, if someone has demonstrated that they are willing to commit a serious criminal offence in the context of this trial, how can one then rely on their compliance with directions? It's unrealistic in our submission in those circumstances. And that's an important factor not to lose sight of, because it, in one sense, one can get wrapped up in the weeds of what happens, and it's important to go into the details, but one shouldn't lose sight of that overall problem, and it's a very significant problem in our submission, and it's just an insolvable one. It may have been deeply regrettable in Jamaica that a trial that has gone on for so long had to be restarted, but ultimately, if that's what's required to ensure that the trial is fair, then that's what's required.
There's nothing in Jamaican law that allows a judge to continue as judge alone without a jury.
No. And my lady's raised that point, and we've sort of thought about it, and obviously there is now in English law, it's a relatively recent development.
Yes, when there's jury tampering.
When there's jury tampering. And if jury tampering is a major problem in Jamaica, in one sense, that's the solution. Millennium Friend says, I'll come on to those submissions, you can't allow someone effectively to derail the trial. But if derailing the trial is a serious problem in Jamaica, well, there is a solution that's been adopted in England but hasn't been adopted in Jamaica. Now, the second incident, I'm not going to spend very long on the second incident. That happened, obviously, that's the incident that led to the release of one of the jurors. And it's addressed, the summary, it's summarised what happened at page 35, paragraphs 35 and 36 of the Court of Appeal judgment, which is at page 5786. And it occurred on the 6th of February 2014. Couple of features of it that I draw attention to. Firstly, it was addressed, and we do express a concern about this, and it's a problem that occurs in the context of the third incident. It was raised in chambers in the absence of the appellants, and we would submit there's no reason for that at all. No consideration appears to be given that.
The source of the problem was thought to be one of the defendants.
Well,
so are you saying that it should have proceeded in open court in the presence of the defendant?
Well, the second incident, and I'll come on to the third incident, and I've got a separate answer to the third incident. The second incident, of course, is, and this is one of the problems about the second incident, is one doesn't actually know, in one sense, what the nature of the problem was, because the questioning came to an end when the juror became distressed, and the questioning in particular didn't address, and there's no material as far as I'm aware that addresses this, what was apparently said by one of the defendants to the juror's son, because she became distressed at that point in time.
Maybe the judge didn't go as far as he should have done in the questioning, but my question relates to where it should have taken place, whether it was in open court or whether it was in the judge's chamber.
Well, there's a strong, I would argue current practice generally is that there is a strong presumption in favour of it being in front of the defendant so that they can contribute. If there is a particular concern, I accept that you can question in the absence of the defendant, but you have to here, the part of the criticism is, in one sense, it just seems to have been assumed it wasn't going to take place. It's not clear what the evidential basis for that or what the reasoning was.
Well, there was a particular problem here which was thought to have emanated from one of the defendants because he'd seen the juror in the prison.
Well, he'd seen what had happened. Yes, but I mean that on its face is not something that's he's to blame for. I mean, on the face of it, it's not his I mean, he appears to have been attending the visits legitimately. There's no suggestion that he'd sort of...
the juror's concern was about a threat to her son.
Well...
A possible danger to her son.
Well, exactly. That's the point in one sense. As it was expressed, it was about danger to her son. Because of the way in which the questioning was stopped, it's unclear whether there was a threat to her son. And they may be distinct in the sense that if there's threats being raised, well, maybe you can hold the questioning in the absence of the defendant, maybe. But of course, the other problem is, in any event, it's not as though this material is being withheld from the defendant per se, because their lawyers will go, but there's no obvious, they're going to know this information potentially because their lawyers will potentially feed back to them. It's just they're not there present, able to give instructions as the matter's being investigated.
Doesn't the bench book say that it should take place in chambers? No circumstances?
I'm going to come to the bench book. I can't specifically remember that. I was going to take you to the bench book. I can't specifically remember off the top of my head what the bench book says, but...
Can I just ask, sorry to interrupt,
yeah.
When you talked a few minutes ago about current practice, and when you're referring now to the bench book,
yes,
are you referring to Jamaican practice and a Jamaican bench book, or to English practice?
I can't remember what I was referring to as current practice, but I accept the point. I need to be careful to distinguish, albeit, can I make this point, that the Jamaican bench book, which I accept, and I was going to make this point when I come to it, the Jamaican bench book postdates the trial in this case, but what it does, which is why we would submit it's of some relevance, is it makes 2 points clear in one sense. Firstly, it makes extensive reference to English standards, recognising that, perhaps unsurprisingly, given that the Jamaican courts apply the fair-minded bystander approach, there is no basic reason to distinguish between English and Jamaican cases. But secondly, it bases what is said in the bench book, unsurprisingly, on historic case law. So it seems to be it's not attempting to set out a new approach. It's on the face of it, it's seeking to consolidate existing principles. So that's why, just to be clear, the Jamaican bench book we would submit is of relevance, despite, as I say, I accept, well, that's why we say the Jamaican bench book is relevant, despite, as I accept, it postdating the trial in this case. And that's also why we say we can refer to English authority, because clearly
never be dealt with in chambers in this country.
Yeah. Yeah. Just to be clear, and just because it is of importance, I think, probably to my lay clients, as I say, their understanding was effectively the primary allegation was that there was an accidental contact between defendant and mother on a visit. They don't obviously accept there was any threat made, and that, as I say, is not. There's the evidence on that is.
I'm not suggesting there was a threat.
Yeah. Just also to be clear, because I've looked it up in the moment, I can't see in the Jamaican bench book a reference.
Well, I found it. It's paragraph 7.
Yeah. Sorry.
It's in paragraph 54 of your case.
Okay, I'm sorry.
7, it says, however, if there's suspicion about the defendant's conduct in the irregularity, then the hearing should take place with all parties represented, but in the defense.
Oh, sorry, yes. No, I found it. Yes. Yes, but I mean, in one sense, that's the difficulty here, is that one of the problems with it, which we haven't particularly, well, we have sort of raised, one of the problems here is, of course, that the way in which this would play out in England and Wales generally is you would have a clear record of what the juror was saying, because they would produce a note. So they would say, potentially, in this case, in terms of the jury, the note to the judge, they would potentially say, I have been, my son's been threatened. That might have one consequence. They might say, I'm just a bit concerned that one of the defendants saw me at a prison visit, and I'm concerned that might have implications for my son, or something like that, which is a different, because that's not alleging misconduct. It's a different reason for potentially being disqualified. But you'd have a clear record early on, and so the judge would then be in a position essentially to invite submissions in the presence of the defendant. There's no reason why the defendant wouldn't be aware of that note. They'd be entitled to be aware of it, as to where and how the questioning should take place. But of course here, it was much more informal as to how the issue was raised. And that seems to have led to just the judge adopting the approach he did. And that is one of the complaints we make, to emphasize this, is that because of in one sense, the informal way in which a lot of this was dealt with, there isn't a very clear record of how certain key acts were taken. And I'm particularly thinking then, in relation to that, of the role the forewoman then takes in terms of sort of reassuring the jury. And going back to this incident, probably more important than the point I just was making, which was that this was in the absence, is that if you look at going back to paragraph 36 of the Court of Appeal's judgment, one of the things that happened was that the forewoman indicated that she would soothe everyone's mind, I think is the language used. That is, in our submission, quite clearly not the same as giving a helpful direction, partly because, it goes back to the point I was just making, there's simply no record of what she does. One doesn't know what she says. One of the reasons why direction is so important in our submission is because it means there is no doubt as to what the jury are being told.
Well, he told, according to the Court of Appeal, he told the jury that she had a personal difficulty that meant she was no longer able to serve.
He told her that.
No, he told the jury.
Sorry, no, yes, you're right. He told the jury, but the problem is that in one sense is part of a package. I mean, because what the Court of Appeal say before that, and they expressly rely on this, what he was told before, and certainly the judge doesn't stop the forewoman doing this, is that she was also going to effectively as I say, soothe everyone's minds. And the problem with that is that that's her, in one sense, giving guidance to the jury in circumstances where you just don't know what that is. Now, the other two problems.
What's the prejudice that you say flows from this first incident?
There are two other factors I was just going to draw attention to, which are perhaps more important in terms of prejudice. And the first is that because, in one sense, of the limited questioning, one simply doesn't know what the juror who was discharged had said occurred, whether there was a threat. And that's important because the other point we submit is that although the Court of Appeal at para 36 says that the forewoman had said others had not been told, what that seems to be based on, as far as we can see at least, is that if you go to the electronic bundle 4079, if you go to 4079, you see at 4079 the forewoman describing what occurred when she was told about this incident. She says she has a private conversation with the, she says she has a private conversation with the juror who had concerned the juror who was discharged. What she doesn't, on the face of it, ask of that juror, and what that juror isn't asked, is whether that juror has spoken to others. And that's in one sense, the biggest problem here, and that's where that's the context of what then follows. To use the language that the Court of Appeal has used, and I've used based on the Court of Appeal, one has here a potential source of poison, to use the Court of Appeal's language. In other words, something that's potentially adverse to the defendants, which may or may not have been in circulation, and on the questioning, because the questioning is limited, one simply doesn't know. You have the juror stopping at the point where she's about to describe what her son says. So we don't know what she says her son said. Was her son threatened? And one has the forewoman saying, I discussed this in private with this juror.
So at the moment you're at
4079.
479.
Sorry, the ending of the questioning, which is just the prior reference I gave, that's 4075, just so you've got the reference.
Just bear with me. Thank you.
And then 4079 is where there's the discussion, or where the forewoman between lines 6 and 20, particularly 15 to 20, she describes how she becomes aware of this. And she says that's in private.
So what do you say should have happened, ideally?
At the very least, because of the fact that there is, and I've identified where it should be, whether it should be in public or private, but at the very least, and this is the critical point, because of this concern about poison, it was necessary to know whether the juror who was going to be discharged had spoken about this incident to anyone else other than the forewoman, and if so, what she had said, and in particular, whether she had made any allegations effectively that the defendants had made threats, anything really that went to the defendant's bad character.
There wasn't any suggestion, was there, that they had made threats?
Well, the problem was, if you go back, it's why I was drawing attention to.
They were simply on remand in the same facility as her son.
Well, it's a bit more complicated than that, my lord. If you go back to 4075, which is what I drew attention to.
Yes, I read it. She's obviously in a very emotional state and she's worried about her son. But
it's a bit more than that. In paragraph, if you look at line 5,
yeah.
Her son says that Kartel, who's one of the defendants, said to him, if ... Then Kartel said to him, if he ... Then it gets stopped. So she is saying...
I'm sorry, where are you reading?
4075.
Yeah.
Line 9, yes, line
9.
Yes, 9 is, yes.
Yes.
5. So she is saying, one of the defendants approaches my son and tells him, and we don't know what he tells, what her son is told, because at that stage the questioning stops.
Yeah.
So that is in the context of her saying, I don't feel my son is safe. So the question is, in one sense, what is her son told? What is that the basis on which she thinks her son isn't safe?
Well, speaking for myself, I thought it was pretty clear from 14 to 17, where she says, Your Honour, the only thing I'm concerned about is my son's safety. They are there, he is there. They know him. And in particular, one of the defendants was on the same block.
Well, my lord, I don't want to spend too long on this, but that's got to be viewed in context. The question is, why does she think there's an issue with safety?
Well, it's pretty obvious, isn't it?
Well, there are not entirely, in the sense that she's trying to recount something that her son is told, but she can't do it. I mean, so whether that is part of the reason why there's a concern about safety. But my lord, I don't, if you're not with, but my lord, we would submit that the critical thing here is that the forewoman is certainly told something about it. She gives some evidence about it. The question, you need to know, in one sense, whether there's a threat because she told that. But more importantly, in one sense, there is also others who may have been told, because on
there was speculation that there may have been a threat and that the juror may have told the foreman about such a threat.
Well, my lord, but I would say it's more than speculation on the basis that she gets very distressed when she is clearly saying there's contact between my son and the defendant, and she gets distressed at that point. Now, so it's not entirely speculative in my submission in that context, because it's clearly distressing for her to describe what her son is told, and she finds herself unable to tell.
Or it may just be it's distressing that her son had contact with the defendant.
Well, it might be, but in one sense, that's exactly why it's important to get to the bottom of this, because you don't, and in one sense, it's the context of what then follows in the third incident, because you've got this problem of uncertainty about what prejudicial material the jury might have. Now, in terms of the third incident, can I move on to the third incident? That is obviously right at the end of the trial. It's described in the Court of Appeal judgment at paragraph 37 and 38. Now, the context of it, and one shouldn't lose sight of it, is that we now know that one member of the jury, consistent with what was being said at the time, was subsequently convicted of perverting the course of justice.
Attempting.
Attempting, sorry, yes, attempting, sorry. Because of the attempt, and yet, if this trial was going to proceed to a verdict, he couldn't be discharged because it's quite clear you couldn't lose one more juror under Jamaican law. Now, again, the issue was raised in chambers. It was raised by the forewoman who was questioned by the judge. Now, it's important to recognise, in one sense, what she says, that some of the detail of what she says.
Well, in fact, looking at this, we're told at the top of 4074 by the witness what this defendant said to the juror's son. Line 2, saw him and see his mother a juror.
Well, but what happens at 4075, it goes beyond that, because there is, the language used was, which is what causes her to get upset, was he was saying if. That has, I mean, that's the start in one sense of a threat. That's why we're raising it, because there seems to be a suggestion that if something happens, something else will happen.
Right.
So, and that's what she can't, and that's, as I say, the reality is that the judge could not be aware of what she in particular had said to other jurors. Turning then to, well, I've already gone to the third incident, and paragraph 37 onwards of the Court of Appeals judgment, page 5787, made the point, I think, already that, of course, one needs to recognise that ultimately the reason why this became an issue in part was because you couldn't discharge a further juror. It was raised again in chambers in the absence of the appellants. It was done by questioning the forewoman. She, at 5168, indicated that she effectively had contact with the other jurors, and to use her language, they had confessed to her. That's 5168. My notes are right. She refers to that. So she'd apparently carried out investigations and told them not to be swayed. She made it clear that she appears to, as I say, investigated it and discovered, according to her, that had taken place over what she describes as a period of time. And at 5172, she says that the 11 of the jurors had been spoken to, in other words, the full jury. And she said at 5168 that she'd told them not to be swayed. But of course, none of the other jurors were questioned, none of them were asked about whether they felt able to carry on.
Sorry, I've missed the point about all 11, you say, have been spoken to by whom?
By the forewoman.
Yes, I see.
You see that 5172 letter 20, line 20 rather, not letter 20.
Thank you.
11 of us. Yeah. She says 11 of us were spoken to. He spoke to 9 persons first. I mean, on the face of it, that would include the.
I was going to say, that must include juror 11? So it must have happened before juror 11 was dismissed.
Well, on the face of
what she said.
On the face of what she says, and of course she talks about. I've indicated already. She talks about over a period of time. So the implication seems to be that this was not something that had happened that day, effectively. But obviously, because there's no questioning of the jurors, one doesn't have very much detail. Well, one doesn't have any detail about that. Individual jurors aren't asked, for example, how long they've been sitting on this. Now, nothing in the evidence is said, and this is important in our submission, about the source of the bribe. The judge may have assumed that the defendants were involved. or some of the defendants were involved. But there is no evidence of the source of the bribe. That it's speculation to suggest that the defendants were, or any particular defendant, perhaps in one sense more importantly, because each defendant obviously has the right to be tried by an independent jury, whether any particular defendant was involved in the bribe. Now, the defence, in contrast to what happened in relation to the second incident, clearly did object to the matter continuing, but obviously what the judge did was remind the jury of their oath. Now, the approach of the Court of Appeal in my submission is...
Whether it's breaking news or learning something new, we have all your favorite programs whenever you want.
I know the role.
Paragraph 238. Court of Appeal indicate that there was nothing to be gained from further questioning. And at worst, it could have required the discharge of the jury. That's important in my submission because one way we would submit of potentially paraphrasing what the Court of Appeal says is that had there been further investigation, there is reason to believe that what could have come out was further material indicating how the fair trial was impossible because of the attempt at bribery. And that, we submit, if one's looking at the fair-minded bystander approach, cannot be right in our submission, because if there is uncertainty about what will come out, and there is reason to believe that what will come out demonstrates that there is a lack of independence, then the fair-minded bystander would, in our submission, be bound to say, well, in those circumstances, there has to be a real risk that there was bias, because who knows what the answers would have been. They may have been the ones that the Court of Appeal feared. Now, the respondent's answer, in one sense, seems to be primarily that there's no obligation to discharge the jury because anyone could bring a trial to an end then by simply offering bribes. They use the language of win-win. We don't accept that's right for several reasons. Firstly, we would submit, and this is perhaps the most important reason as a matter of principle, each of these defendants had a right to be tried by a jury, and they didn't waive that right. Come on to the case law in relation to waiver. In those circumstances, there is no basis, essentially, for denying them that right. But secondly, in our submission, which is equally important, and it goes back in one sense to the case law I was taking you to earlier about constitutional breaches, it makes assumptions which in our submission can't be made good in the absence, in particular, of any investigation by the judge as to any further investigation by the judge as to the way in which the bribes were offered, etc., because it assumes each of the defendants was involved in this in circumstances where there's simply no evidence of that. I mean, if you think about the question my Lady Simler put to me about what would now happen in England and Wales, of course, what now happens in England and Wales is because potentially there would be trial by judge alone. The rights of the defendants are still protected because they still have an independent tribunal trying their case. Now, we say that the way to approach what happened is to focus on the case law regarding bias. Two authorities, I mean, that case law is obviously extremely well known, but two authorities that I would draw attention to. Firstly, Lowell, which I'm sure the court is well aware of, was which was the UK Supreme Court applying Porter and McGill. The reason I draw attention to it is because it contains a little more detail about how the fair-minded bystander approach applies. And in particular, if you go to Authorities Bundle 6318, two points I make about it is, having set out the well-known fair-minded bystander test, the Supreme Court, by letter C, makes it clear that public perception is key. And that's, in our submission, one of the reasons why it's open to this court to look at what happened in the round, because ultimately, if this is concerned in one sense with public perception, when the public look at this trial, in our submission, it is bound to have concerns because of the ultimate extent of the departures, essentially, from what is generally regarded as fair practice. The other point that we'd make is that in paragraph 15, the point is made that the fair-minded bystander doesn't come to this issue with a clean slate. They can look at analogous situations, etc., and rules in other contexts. And that's important in our submission because it does mean we can make reference to things like the bench book. The other authority that we draw attention to, which is an application of the fair-minded bystander test in the context of a jury, is the Brown judgment at 6330 of the Authorities Bundle. And Brown is important in one sense because it is an example of the approach adopted in the context of a bribery case. Now, the reason why I particularly focus on that is that if you go to paragraph 38 at the bottom of 6330, halfway through it, you see the court applying the fair-minded bystander test. But then, and this is the important thing, dealing with, and this deals with the argument the Crown put essentially about the defendants being, or the appellants being, the author of their own misfortune, it rejects essentially the argument essentially that it was appropriate for the judge to rely on the defendants being the authors of their own misfortune. And the reason for that you see in perhaps expanded in considered in greater detail. If you go back a page to paragraph 31, is that for that approach to apply, it must be either agreed or ascertained, can't be assumed. What the prosecution are essentially doing is asking you to assume that the defendants were responsible. It's entirely speculative, that. One other thing while we've got this open, so I don't have to go back to it. Unsurprisingly, we would submit, the Court of Appeal does consider the proviso, but rejects it fairly summarily. They do that, if you go back to the 6330, last line on page 6330, and the next two lines on the next page, recognising the fact that they had a strong prosecution case, but making the point essentially that there is a right to trial by
Impartial.
by an impartial tribunal of fact. I'll come on to the proviso in a moment, but we would submit that's unsurprising. If there is a right to trial by jury, and that jury must be independent, it's difficult to see, we would submit, how it can be right to then effectively deny a defendant that right by applying the proviso, because that will be a conviction without the evidence having been considered by an independent and impartial jury. Now, the Jamaican bench book is, first, given what I made about the point I made about Lawal, is perhaps the starting point, and that's at 6790. And as I've already indicated, I accept this postdates the trial, but as I've said, it on the face of it, given its reference, given it extensively references earlier case law, is not on the face of it intended to be some sort of revolutionary approach to fair trials. It is intended, we would submit, to be a consolidation in one place of learning from both Jamaica and England and Wales. A lot of it is, in fact, from England and Wales.
Just before we leave the authorities, I'm surprised you've not taken us to Putnam.
I will take you to Putnam. All I was doing was to put in context. I wanted to, the structure, I should have perhaps explained the structure of my argument. The way in which I was structuring the argument was to look at the general test, the fair-minded bystander test, to set that as context, then go to some of the relevant practice directions, then go to the more specific case law, and I was going to come to Putnam at that point. So, my Lord, Putnam is obviously perhaps of particular importance. It's obviously where I've made repeated reference to the spread of poison, and that's where I think it's Putnam from memory where that language of spread of poison comes from. That's obviously of key importance. Bench book is 6790, or there's actually some other passages of the bench book which are later in the bundle for various reasons, but the key passage for this issue is 6790, recognises at paragraph 3 the potential importance of discharging a jury for misconduct. Misconduct is footnoted to a case that makes it clear that includes bribery, then references the UK practice directions, recognising, we would submit, consistent with the fact that, as we've made clear in our statement of case, the approach of the fair-minded bystander is adopted in Jamaica as it is in the UK. I think they refer to it as the UK practice directions. Given my Lord Lord Reed's role on this court, I think it's more accurate to say the English and Welsh practice directions. But the point is there. More importantly, and this is really what I wanted to draw attention to, perhaps, is paragraph 5, making it clear that it's the duty of the judge to investigate whether or not a juror has been compromised, to enable the judge to make an informed decision. That is described as a duty, and in our submission, it's not surprising in light of, and it's one of the reasons why I went to the bias test first, in light of the bias test. If the issue is, and we submit it is there a real risk of bias in the mind of a fair-minded bystander, then if there is uncertainty, that means you can't rule out the real risk. The information essentially allows a judge to decide the extent to which there is a risk of prejudice and the extent to, and what steps need to be taken to address that. It makes it clear also that if jurors are discharged, they are entitled to an explanation. And perhaps more importantly, looking at the first, or the second incident rather, they may need a direction as to disregard comments from the discharged juror. And that's, if you think about the second incident, I've complained in one sense that we don't know whether there was contact between the discharged juror and others about this incident, and we don't know what was said because the juror the questioning of the juror stopped before she described the incident at the prison. Arguably, at least one way of doing that, which might have limited the poison, would have been to be more specific, essentially, about the need to disregard anything the juror might have said. And that's what happened in Taylor, in fact, we'll come to. The bench book goes on to recognise, essentially, that misconduct may require the whole jury to be discharged before verdict. It doesn't say very much about the circumstances, but certainly recognises that that is one way of potentially dealing with the issue of jury misconduct. So that, in our submission, is, in one sense, the Jamaican guidance. As I say, I accept it post-dates, but it's meant to reflect Jamaican practice. The other authority that's worth paying attention to, not least because it's been applied by this court in the Taylor case, was the guidance, because it is closer to the time of the trial, and as I've said, there's every indication that standards in England and Jamaica are no different. There is the guidance issued by the President of the Queen's Bench Division, Sir John Thomas, as he then was, in 2012, and that's at 8161 of the bundle. A couple of things that it adds that aren't necessarily clear from the Jamaican bench book is, firstly, it makes it clear that, in one sense, the first step, which can happen in open court, is to invite submissions from the advocates. Secondly, probably more importantly, it makes the point before that about isolation, that there may be a need to isolate jurors who are who perhaps have given rise to concerns. The reason I draw attention to that is not because it necessarily was clear that by the time the problems arose in this case, isolation would have made any difference, particularly in relation to the third incident. Obviously, on the forms evidence, everyone in the jury knew that one of their members was trying to bribe them. The reason I draw attention to that is that if one thinks about the underlying purpose of that, it links to the point that's made in Putnam about the importance of isolating the poison. It is a recognition in our submission of the approach in Putnam that once something is going wrong, there is a real risk that information can spread within the jury, that, as I say, to use the language, poison can be spread.
In one view, you don't even need to go that far. I mean, if the judge was satisfied that one juror was trying to bribe others,
yes,
then it would follow that that juror was not performing his duties as a juror properly, as giving an impartial verdict based on the evidence, and therefore should no longer continue to serve. And if you get that far, then the trial has to come to an end, because under the legislation, in a murder case, there must be a verdict can only be returned of a jury with at least 11 members.
Well, my lord, in one sense, that's why, and I started this morning and then started the submissions about juries by saying, I'm going to go into the detail, because obviously I want to take every point I can, because I want to...
Yes, I appreciate that. I mean, I'm really making it's a two-level thing. I mean, on one view, once you have one juror who is clearly suspect, that's an end of it.
Well, exactly, my lord, and that's why I started making that.
And you don't even need to start thinking about what the impact might have been on the other 9.
Absolutely.
But I appreciate that's a further argument that can be developed.
Absolutely, but my lord, I deliberately started with that point, because in one sense it is really important not to lose. And of course, my lord used the language of suspicion. We know he was now convicted of that, and I think that's the question for this court: was this an independent, impartial trial? And in light of what we now know, it's difficult to see how it could have been when one of the jurors, and one of the jurors who had to be there, was subsequently convicted of essentially being involved in the bribery. Well, I said I'd take you, my lords, to Putnam, and I will now, if I may. Yes, can I start at least by Putnam, because I'm just conscious of running out of time. Putnam's at 7577, and it is another bribery case. In that case, unlike this case, the bribe was not something that the judge was aware of until after the trial, but the judgment clearly contains important guidance on what judges should do if bribery becomes an issue during the trial. This was also a case where the bribery wasn't internal to the jury, it was an external approach. The critical point, really, though, that comes out of this is that while the Court of Appeal, presided over by Lord Justice Bingham, as he then was, recognises that there may be circumstances in which a juror who is approached with a bribe can continue to sit, it seems to imply several things. Firstly, if you look probably about 10 lines up from the bottom, Lord Bingham was of the opinion that the juror who was approached can only continue if there's not impropriety, and there needs to be a very emphatic direction. But given perhaps that reference to the need for impropriety, there is a particular concern Lord Bingham makes clear if the juror who's approached delays coming forward. And you see that at the bottom of page 758, that paragraph and the whole of that paragraph, because the concern is...
Sorry, 758.
Sorry, 7578. It's the last 2 lines, and then the paragraph goes over the next page.
Right.
And what Lord Bingham seems to be saying in those two, in that passage, is that if there's delay in a juror coming forward, that raises 2 very important questions. Firstly, is that juror failing to comply with their duty because they're not drawing attention to the bribe? And secondly, the longer the problem continues, the more there is a risk that the bribe will have unconsciously influenced. And that's the context of what Lord Bingham says at the end of 7579, the bottom, the last 10 lines.
It's also it's quite helpful, perhaps, just to see the test, as it were, being applied on that page, 7579, lines 5 to 6. The judge would not, we think, have felt able to eliminate the real risk.
Never miss a beat with TD Clear. No interest, just a simple monthly fee.
One or some defendants. So that seems to be the test is applying a real risk of prejudice, either conscious or unconscious.
Yes, and that's, of course, one of the problems with the approach to the other jurors, is the other jurors may say, oh, I think I can reject this bribery attempt. But of course, they then got something, a very prejudicial piece of information in their minds, very difficult potentially to eliminate that. And of course, that test was being applied before Porter and McGill and before the adjustments, relatively slight adjustments, but the adjustments that were made, the introduction of the fair-minded bystander test. But it still echoes that test because it's applying a real risk approach. So and our submission remains valid. And that, the approach you described, it's just worth looking at the bottom, as I say, the last 10 lines in particular of 7579, where Lord Bingham essentially focuses on the need for his language, collective integrity and individual integrity. That's obviously a problem if you've got one person who's offering bribes. It's impossible to see how there's either collective or individual integrity. Deals with the issue of potentially isolating the poison, but recognises there's a real problem if you can't isolate it. And of course, here, the poison couldn't be isolated because the judge allowed the juror offering bribes and everyone who knew about those bribes to participate in the decision making, in the verdict. I've slightly overrun, but that's probably a good point to break for lunch.
Yes. Thank you, Mr. Sully.
Sorry, I assume that's probably a little presumptuous.
It's a convenient moment for the court as well. We'll adjourn and resume at 2:00.